Good afternoon. Welcome to our live Zoom/Facebook Live webinar. Quite exciting. We are allowing people on this specific webinar to pose questions. So I'm dealing with two specific platforms. I'm dealing with the one platform being Zoom, where people registered for this webinar before the time. And my second platform I'm dealing with is Facebook Live, where people are watching it live. Please note you are welcome to engage with us in this webinar if you are making use of the Zoom platform. As I mentioned early on, only your voice will appear while I'm engaging with you and not your face. Only the screen which is in front of you will appear, and those watching it on Zoom will also see exactly the same screen, and you can engage with me in that regard. Therefore, if you want to engage with me live and speak during this webinar, please send me a quick message on your Zoom and say, Advocate, I would like to ask you a question, and then I'll unmute your microphone, or you might mute it yourself, and you can start chatting and we can engage. And I will deal with it on that basis. There are about, let's see, 13 questions that people posed. The participants have posed those specific 13 questions, and I will deal with those specific 13 questions as we go along. The time of the webinar will be approximately an hour to hour and a half, depending upon how many people engage with us. And hopefully there will be a lot. I'll give it 30 more seconds for anyone else to join. I'm seeing people are joining via the Zoom platform. And then I'll deal with the first question. And as we go along, you can pose your specific questions as well. Remember, those who are seeing these questions are persons or people who have posed these questions when registering for this webinar. I'm sharing it to a group quickly. Post. And share it one more time. Post. Okay. Thank you once again, and let's start the specific webinar. You might not be able to see all the questions I can see on the Zoom screen. It might not all appear. I'll try something else quickly so that you can make it will be easier for you to see. Maybe that, I do not know. So you can see the whole question. I'll move a bit to my left. Hopefully that helps. The first question is, I'm separated and not receiving child maintenance from my spouse. Went for interim order. He said he doesn't know the child. He delays DNA test. It's 5 years. Child is 10. Can I claim the years for 5 years? This specific webinar does not deal with child maintenance. It is about how to win your care, custody, and contact case in the High Court. However, because you have posed this question, I will deal with it first and quickly as well. If someone is not the father of the child, he has no obligation to maintain the child or support the child. I almost said she. If you are not the father, you have no legal obligation. Therefore, the court has a legal obligation to ensure whether or not you are the biological father, because how can you order someone who is not the biological father to pay any form of child maintenance? What does happen sometimes, a party or a parent or a father, in this specific case, will dispute paternity initially, knowing well he's a father of the child, in order to delay the matter, because he knows that the court cannot finalize this matter unless paternity is resolved. Under your circumstances, seeing that the father delaying paternity is etc., I'm a bit disappointed in the sense of the court. The court has a legal obligation to ensure that matters are expedited. And if a party does not partake in the paternity testing, the court can make a presumption and assume that he is a father of the child and make an order that the specific party must pay child maintenance. So in your circumstances, my advice would have been initially go to the maintenance court and have them expedite this matter, but clearly they are not. And it could be bad reasons for that, or maybe good reasons for that as well. So my advice to you is complain, go to the maintenance court, complain to the senior magistrate, to the court official, the court manager, go further up. complain to the Department of Justice, your provincial Department of Justice, and say, I have made an application for maintenance 5 years ago. The father keeps on, delaying this matter based upon paternity issues. It's been 5 years. The maintenance courts are not assisting. They are catering and they are assisting the father in delaying justice. Please do something about it. Your officers down below, the maintenance magistrate, the maintenance officer is not doing their job. Please let them do the job. And if you do not get any assistance or any how can I say now, relief from that, then I would advise you at the same time to go to the media and complain further. So that's my advice to you. This is a systemic problem, not necessarily where the father is concerned. He wants to delay the matter. That is him. But the courts should not entertain delay of the finalization of maintenance matters. I hope you're following me. I hope you hear where I'm going to with this, because if you do your job, you do your job. The same way if I go to Pick and Pay and I buy something, I can't stand in the queue for 10 hours. The process works. I stand in the queue for a few minutes until the next person is finalized before me, and I go through the system. The clerk, if I do wait 10-20 minutes, it's because of the staff not doing their job. I hope I answered that specific question. I need to see it from the actual screen, from the whiteboard itself. Nope, that will not work. You can't see it properly. There it is. The second question is, my ex-husband lied on a letter from his lawyer in the payment he makes towards a medical aid for our son. We have 50-50 custody. May I mention this in my response email to his lawyer? Yes, you should mention it to your lawyer, but the challenge to his lawyer, the challenge you may have is his lawyer will maybe just believe what his client is saying. I would generally also have the inclination to first listen to my client's version of the story, and if it's probable, and if the other party's version of the story is not that probable, I will take my client's version. So that's a problem you have. I cannot see from your question whether or not this matter is pending in a specific court. You say my ex-husband lied on a letter to the lawyer. You're not mentioning about any court matters, and you are 50-50% custody. My quick answer to you will be, if he's lying and based on his lying, it affects your contribution towards child maintenance. Under those circumstances, I would actually advise you to go to the maintenance court and let the maintenance court try to resolve that specific issue. People should not lie when it comes to child maintenance. My view and my belief is a person can enjoy your life as much as you want to. You can drive a nice car, a nice house, go on holidays all the time. But if you do not pay your child maintenance or your child support, clearly I have a problem with that, and the law needs to step in and do something about it. All the participants are presumed in now. Thank you for joining us. We have a lot of participants. Many people register with the idea of getting the video afterwards. We had a lot of registrants, I think quite a big amount. And the video will be sent to you all afterwards. So if you have to leave this video at any point, you can come back again. I will let you in again. And if you cannot watch this entire video or partake, the link to the video will be sent to you, and it will be available on our website and so on. If the participants have any questions and you want to specifically elaborate further on those specific questions, or you want to add anything to it, please feel free to do so. So question number 1 regarding the maintenance, I will entertain it today. You're welcome to add an additional comment, and I will copy and paste that comment from the chat on Zoom into that specific screen. And question number 2, if you have any additional comments, exactly the same. Just mention I'm question number 2, and I'll copy your comment in there, and we can make this whiteboard a bit further. If you have a specific question and you want to consult with an advocate, myself, please mention it in the comment section, and I will allow you to, you can unmute your mic, but I will move your sound onto the screen so everyone can see it and hear it. Remember, this is a live Zoom webinar where participants had an opportunity to register for it before the time. How to win your care, custody or contact access case in the High Court. I'm referring to the High Court because the High Court basically deals with a situation where the parties themselves have to run their own cases. You get an attorney, you get an advocate on board, etc. However, in the Children's Court, the court is more involved in your case. There's clerks. It's like dealing with the topic of how to win your care and contact case in the High Court. However, the same principles and the same concepts could apply to the Magistrates Court as well. So I hope I wasn't and I need to specifically deal with one specific court. I can't say in South African courts because the processes followed in the various courts are a bit different. So therefore, if you have a live question, I can zoom your voice in, and the people out there on Facebook as well. We have a big following on Facebook as well. Many people are watching it. Thank you for that, and feel free to share it. Let's deal with the next question. Okay. What recourse can one take in the instance where the father and his new wife badmouths the mother, which in turn makes the child uncomfortable and now reluctant to go to the father? Let me just take it a bit further. Okay, so there you can all see that. So here we're dealing with a very difficult situation whereby the personalities of the parents are not conducive to the child's best interests. That's what I'm saying. I do not know the commenter, and I'm speaking generally here. When parents divorce or separate, and there's a minor child involved, yes, the relationship has failed. That we accept. There's nothing we can do about it really. However, they can still become the best co-parents possible. And I think you'll agree with me where that is concerned. The same way, if friends at work, they had a bit of a fallout, and you left the work, you can still become very good friends, but you're no longer co-workers. The relationship can go on. The same applies to co-parenting, or where children are concerned. I'm a staunch believer. If a marriage has broken down, it's over, it's done. Your relationship, you are not married, but you have a child together, it has broken down. That is fine. That is life. And that is, you are adults. You need to go on with your life. However, if there is a child involved, a minor child involved, why must the minor child bear the brunt of your failed relationship? You were wonderful spouses when you were together initially. You were in a wonderful relationship when you were together initially. However, now, why can't you be wonderful co-parents? And I mention this to the viewers because we're streaming live on Facebook as well, and many people are watching this video because they are involved in family law matters. And that's my advice to everyone, whether or not you're the father or the mother. If you as a mother have a problem with the other party, I hope the other party is watching this video. And if the other party has a problem with you as a mother, I'm glad you're watching it, and with the father as well. So be the best possible co-parents. But this is a concerning question to me because, I'll repeat the question, what recourse can one take in the instance where the father and his new wife badmouths the mother, which in turn makes the child uncomfortable and now reluctant to go to the father? So the father and his new wife, they badmouth the mother. The child is obviously feeling protective towards the mother, and now does not want to go to the father because they keep on bad-mouthing the mother. So they say a lot of bad things about the mother. That is a serious problem, and it affects the child's mental well-being because now the child must make a decision. Do I stand with my mother, or do I take the beating from the father, where the father keeps on complaining about the mother? Serious issues over here. The advice I have to you, to the Pacific commenter, it's not necessarily legal advice because you can go to the court, and I don't think the court will litigate on stuff like that because contact care arrangement has been resolved already. And I don't think you'll get a lot of joy from the courts because I know you're trying to deal with co-parenting issues. Firstly, as I mentioned now in my last few words, co-parenting. The parties will have to go for co-parenting. If that is not an option, if one party is not interested in that, then I would advise you as a mother to take your child to a social worker and let the social worker speak to the child and find out exactly what the issues are. So you're taking it to a third party. You're not getting involved much over there. You are limited. Your involvement is limited. The minor child sees a third party, and the third party can deal with the child and assist him. The third party in the same breath should, and I'm saying should, not could, should reach out to the father. It's very important. I do not believe in experts only dealing with one party. I think those specific reports or those assessments are a bit useless. Depends on the assessment. If it's blood and serious stuff, and we need to make an urgent, quick recommendation and we only have time to consult with one parent and the child, I understand. It gives me some type of interim relief and interim type of assistance on the specific issue. However, if an expert only consults with one parent and comes with a conclusion on the specific issues, I do not think that expert knows what he or she is doing. Therefore, I say the expert, the social worker, whoever it is, needs to reach out to the father and tell the father, you know what, I had a complaint from the minor child, I consulted with the minor child, and the minor child is advising me that he does not want to go visit you anymore because you keep on bad-mouthing the mother. Father, you might think what you are doing is okay, it's fine, because you might believe so. I mean, you do not see anything wrong with that because nobody told you it's a bad thing. It's like when a parent teases a child or makes fun of a child, in a nice fashion. He or she might see nothing wrong with that, but at the end of the day, it could mentally affect the child in a detrimental way. Same with spouses. Spouses sometimes tease each other, and then a month later, they all start divorce proceedings because it was one tease too much. The father might have good intentions, maybe the stepmother might have good intentions, I do not know, or maybe she might not know what she's doing, or the consequences thereof. If the specific professional or the specific experts consult with the child, consult with the mother, and reach out to the father and listen to the father's point of view, a dialogue might start happening, and that might cause the father to stop bad-mouthing the child. Alternatively, this expert can find out the core reason why the father is doing that. Maybe he has problems with the mother. There are other issues involved. The matter can be much more complicated, but things can become unpacked and things can resolve on that specific basis. If that doesn't work, then I would say you would have to look at other potential avenues. Getting a bit thirsty. When I say other potential avenues, you might want to then relook this whole situation. And I do not like going here because then you have to look at the situation as it is, which is problematic. Having the child visit the dad. The child does not want to visit the dad because the father badmouths the mother. We cannot change the father's personality. We cannot change the child's temperament. We cannot change the mother's personality, which maybe causes the father to badmouth her. I'm not taking anybody's sides. And then, what is the solution? What can a court do? All that a court can do is change the parenting, contact, and access arrangements. That's all that the court basically can do. The court cannot change someone's personality. Surely the court can't change my personality. If I litigate on behalf of my clients and I fight tooth and nail and a judge tells me, Mr. Abdurauf, I think you're a bit too far, you're fighting too hard for your client, you're taking it too far. That's his view, that's his personality. So the same way courts cannot change people's personality. And how does the court do that? Can the court change your personality to be in favor of the one spouse, of your ex-spouse or your ex-partner for that specific situation? But then when you deal with other people, you can be yourself and you can, do things the way you think it should be done. So therefore, a court cannot change your personality. What the court can do, the court can change contact and care arrangements. That's basically all that the court can do. Of course, some other things the court can do as well. But regarding the specific scenario. So my advice to you, ma'am or sir, whoever you are, who pose a specific question, is do that. Try co-parenting counseling, go for coaching, and so on. Get an expert on board if that cannot work. And if not all else fails, relook at this entire situation and find out what is the solution. Is the solution for the child not to visit the dad at all? Full stop. Is that the solution? Or is there something else? I hope that answers your question, and you're welcome to add additional comments to that, or you're welcome to call us live. Let me see anybody else coming in. And I have some chats coming in over here. Let me see what they are. Advocate, I would like to ask a question pertaining to your theme. Signal when you will be dealing with the questions. Okay, that's wonderful. And it deals with... No. Then I have another question concerning parental alienation. We're dealing with that a bit later on. Domestic violence court for psychological abuse towards a child. Okay, then I have another one. Good advocate, I would like to pose a question regarding mine and my partner's situation. Kindly advise when I may ask. Okay, we dealt with those other questions so far. We dealt with 3 questions. We have another 10, and I think we're only now basically 20 minutes into the webinar, so we have a lot of time to deal with that. So the next person who's available to pose a live question, there's a few of them. Can you just leave a comment or send a message, please, and I will say you can go online. There's 2 people, I presume, who wants to do so. Send me a message. Okay, I see the hand going up over there. Let me see that. I'll unmute you and you can start chatting. Please unmute and please go ahead. Then I'll deal with the second person. So the first one is a male who put up his hand, and the second one is a female who put up her hand. I'll deal with the male first because he's on top on the screen and his name came first. Please unmute your microphone only and start speaking. You're welcome to go ahead.
Hi, good afternoon, Advocate. I'm not sure, can you hear me fine?
I can hear you fine. Please go ahead.
Okay, good afternoon, everybody. Advocate, thank you so much for this topic. It's really amazing. I guess I would like to ask a question regarding just certain prejudices that exist in the court system, and how those prejudices also carry through to the High Court, or if they do carry through to the High Court. I know from experience that as a male, I am currently on the back foot in terms of my case, because of the fact that I'm a male, and certain preferences are allowed and afforded to my ex-wife that aren't afforded to me. And so I would like to know, do you perhaps know what are the percentages of cases that are won, compared to females versus males? And also how those prejudices carry through from district, regional courts through up until, the high courts. Are those prejudices also, do they exist in the high court? And also, what advantage do I have in terms of being a single father and obviously taking my application through to the high court? Thank you.
Sorry, thank you for that, and I will answer the question. I get a question posed a lot. Many people are of the assumption that there is a preference to a certain gender regarding a certain legal matter. For example, in a child maintenance matter, if I have a female client and then she will say, the courts are always in favor of the dads. The dads do not have to pay child maintenance. They find always in his or her favor. And then when I have a male client in front of me, then the male will tell me, the courts always find in favor of the mothers because they give the mother what she wants. So regarding child contact and child custody as well, there seems to be that problem where people are assuming that there is a preference towards a certain gender regarding a certain matter. It's always the opposite gender, put it that way. So if I'm a male, so I presume that the courts are in favor of the females and the females believe the courts are in favor of the males. My experiences as an advocate, and maybe I have the advantage because I'm a lawyer, I'm a legal person, and I represent clients. And my experience over the years were that there is no such preference. And that's the advantage I have. And also I have insight in the sense of I've been dealing with this matter now for 18 years. I'm admitted now as an advocate for 18 years, and I've been practicing, let's say, for 17 years, or 18 years, depending upon, I need to be honest here. So I've been practicing as an advocate for 18 years. And my first matters which I've done was child maintenance matters. That's where I got a lot of popularity regarding challenging the law where it said you cannot claim maintenance from paternal grandparents of children born out of wedlock. And so the law changed. So there, you could have said the law was a bit unfair because the law at that time, 18 years ago, 17 years ago, said that if you are a mother of a child born out of wedlock, you cannot claim maintenance from the paternal grandparents of children born out of wedlock of the child. You can only claim maintenance from the maternal grandparents if there's a case for grandparents to come on board. So there, that mother told me, this is unfair. We as females, we are being discriminated against because the law is in favor of dads. Okay, the courts came, I dealt with the matter, I argued it, I took it to court. to the High Court, and the court made it equal the playing field. You can claim maintenance from paternal or maternal grandparents. So regarding child custody and child care, my experience over the years were that there is, as I mentioned earlier on, there is no such, preference. There is a human preference whereby a certain magistrate in a certain court, he might have a certain template in his brain, whereby he, or let's say she as well, prefers to afford certain type of relief based upon your gender. I've experienced it in the High Court as well, where a client, in a recent matter, where a client, I represented a client, and we were allocated a certain judge, and I told the client and my attorney the day before, we are not going to be successful here because I'm representing the male. And this specific judge, in my experiences in the past, always, gives the woman a good deal. And at the same time, I appear before a different judge, and I know this judge is a fair judge. He finds, black and white. He gives fair decisions. He looks at the mathematics and he does that. And I'm certain there are many magistrates or courts, maybe they are justified in that regard, based upon their personal experiences, his personal history. They might have been involved in a relationship in the past whereby they approached the courts and they felt that they were being discriminated against their gender. So to the specific commenter on Zoom, I cannot give you any statistics because I have not, in a holistic sense, experienced that the legal system is based upon that, whereby there's a preference for a certain gender. I can tell you that there are specific magistrates who are, some of them are lazy, and some of them are not lazy. Some magistrates know the law very well, and some do not know the law very well. And some magistrates prefers to give certain type of relief favorably to a certain gender and not to a certain gender. So I cannot answer those statistical answers, but based upon my experience for the last 18 years practicing family law, generally, I could not see, and I do not experience that there's a general preference within the legal system itself to assist a certain gender as opposed to another gender. Yes, possibly within a magistrate's court or within a certain magistrate, he or she might have a certain preference. So I hope that specific answers your question. You're welcome to come back online again shortly thereafter, and I will answer whatever additional questions you may have. I have the lady whose hand is up on the Zoom. You're welcome to unmute your microphone and pose your question.
Hi, advocate. Can you hear me? Thank you, and hello to everybody that's joined. Firstly, thank you for discussing this. I think it's something that, it's so vital for my particular case and my partner. So just to give you a brief rundown so that you understand, I am dating a guy for the last 3 years, and he has 2 children with his ex-wife. Unfortunately, their divorce has also been carrying on for the past couple of years because, it's been a back and forth thing where she does not want to agree to the settlement offers, and it's just been back and forth with her. So she began alienating his kids when about 2 years ago. And despite his agreements with the attorneys, with her attorneys and his attorneys, they'd agree that on Father's Day or on birthdays, alternative weekends, he'd be spending the weekends and stuff with him, with the kids. And she would just never stick to the agreement. She would always pack up the kids and then be gone, and no one would be able to contact her. And 2 years ago, she also assaulted me in 2 venues in one day. She assaulted me with a baseball bat, and this was all done in the presence of my partner's 10-year-old daughter. And his children have definitely been very emotionally traumatized, and I do have a criminal charge that's against her, and she's supposed to be going through for trial, and this matter has been going through for the last 2 years, and she's basically been trying to tie in every time something doesn't go according to her way at the criminal matter for the assault, then she takes it out on the kids or my partner by preventing access to the children. And, during COVID last year, he provided his kids with their own telephone so he could contact them, and the phone was switched off and he was not able to speak to them or even like see them for 10 months. And eventually he managed to gain access via the maintenance court. And he's only been seeing them now for the last 2 months. However, he would like to, look at his options in gaining primary residence for his children.
No, thank you very much for that. I think you're done, so I can give my comment on that specific issue. Thank you very much for the commenter via Zoom. I will answer the question now. If anyone else wants to pose a question via Zoom, ask a question, you're welcome to do so. You must just put up your hand. I think that's the way to do it, not message me. I'm also learning as we're going along here. So put up your hand and I will deal with you next. So regarding the last question I had, clearly parental alienation, and that's a problem we have, and I see it all the time. I see parental alienation all the time, and sometimes the challenge is, how do you identify it and how do you convince the relevant person who can make a decision regarding parental alienation to deal with it? So for example, the judge, whereby certain type of stereotypes comes in. Let's say the mother, her job is to alienate a minor child from the father. That is her duty in life. A job which she vowed to, fulfill and become the best at it. So at any point at which the father wants to be involved in the minor child's life, in whatever way, exercising contact or enforcing his rights, she will make it hard or very hard or maybe possibly impossible for the father to have such type of contact with a minor child. Regarding the specific commenter, my advice to you is you need to get some type of relief here. You need to find a solution that will resolve the specific problem from happening in the future again. Clearly, the mother does not care about court orders. But you need to start playing her game. Her game is parental alienation. Your game should be using the law as a tool, but correctly, in order to assist you in finalizing your matter or getting some type of results. The challenge which you have is many attorneys or lawyers do not want to play this game. I'm calling it a game, but it's a serious matter, whereby if a party violates a court order in any way, you need to put that person to terms. One example would be, for example, a contempt of court application. But the energy behind the contempt of court application is very important. If you go to a certain type of an attorney, and I'm being general here, and I'm referring to nobody specifically, and if you feel I'm referring to you, then you're welcome to leave a comment or message me later or phone me later if you're an attorney or an advocate or whatever it is. But if you go to a specific legal practitioner, and that legal practitioner knows that if somebody violates a court order, he or she may approach the court and make a contempt of court application against the other party for non-compliance with the order, willfully, etc. And the potential consequences thereof could be either the court can either force a person, please adhere to the order, and if you do it again, the party can come back to court and I'll give more stringent relief, or the court can make a order that the person must be jailed for a period of time, which is generally suspended on condition that you do not do that again. So those are the relief you've done. But if the lawyer you approach has a very, put it that way, a very slow, a very weak punch in the matter, whereby he delays matters, and maybe his purpose at the end of the day is to make as much money as possible from you, so this matter can be delayed. As I say, a good lawyer is one that resolves the matter very fast, and a very, very good lawyer is one that takes forever with a matter, can make millions of rands off you. That's a joke. But that principle sometimes applies. So people feel frustrated with the legal system because the matter takes so long. But it's your lawyer, it's your attorney who is taking so long with this matter, or your advocate. I'm an advocate as well, then I blame my profession as well. The matter needs to be dealt with quick, because the first time the parent tried to alienate you from the minor child, he or she most probably got it right. So what's a mental way of thinking? It's if I do these things, nothing really happens. you know, something could possibly happen, but my ex-spouse, my ex-partner doesn't really do anything about it. He or she basically leaves things the way they are, and I can get away with it all the time. So therefore, it's very important that you find a legal strategy, you stick to it, and you execute it as soon as possible. So your last comment to the person that last speaker, last live speaker was, he would like to apply for primary key. Maybe that is a solution. Maybe that will resolve a lot of things, because then if he has primary care over the minor child, then he will obviously not try to alienate the minor child from the other party. And then that could solve so many difficulties and so many problems, because the alternative of that would be we have a serial parental alienator on our hands. Her job and duty, as I mentioned earlier on, is to alienate the minor child from the other parent for the sake of actually punishing the other parent for some unresolved issue she might have. So my advice to you is, parental alienation is a serious issue. Set up a legal team, or yourself. You do not need to have a lawyer. If that is your attitude and you want to resolve this matter, if you are making use of a lawyer, push the lawyer all the time. Do not just take his or her word. You need to apply your brain, and you need to put some energy into the specific case. If you cannot afford legal representation, do exactly the same thing. Handle your matter on your own, but finalize it as soon as possible. People get tired of people nagging. So, for argument's sake, if the legal system is not giving you joy, you complain, they give the paragraph, which they have told so many people over the years, and you leave. Wonderful, that worked. But if if you're adamant and you become pesky, they will surely give in. So my advice to you is, you're welcome to reach out with me later on if you want any additional advice regarding parental alienation. But I would say most probably the issue is strategy. Don't give in. I deal with parental alienation matters on a regular basis. I can see it a mile away. And my view, the best way to resolve the matter is not to give the other party an opportunity to get away with the first strike of trying to alienate you from the minor child. I hope that answered that question. If it did not, please leave an additional comment and I'll try my best to deal with that. I see no further hands up. If you have any additional hands up, please put up your hand and I'll be able to see it on the screen, and I will give you the microphone, for lack of a better term. I think we should deal with the live question, the registration questions. Where am I now? There's it, question number 4. How does one tackle parental alienation in this particular case? An ex-wife has falsified various charges and even had the father of the children falsely arrested for domestic violence. So we're following up on the issue concerning parental alienation. Yes, a serial parental alienator is a big problem. I dealt with grandparents who were parental alienators, where they took the mother of the child to court, or the parents of the child to court, and it was more of an issue concerning control, where they wanted to control the situation. They might have had a bad relationship with their kids, but now they see a grandchild, they see the grandchild as as fixing problems that they did not have with their specific children. So they fight for a primary care or care for the minor child. They attack the mother's lifestyle, the father's lifestyle, etc., so that they can, for lack of a better word, poach that child. But nonetheless, with your specific case, it's all about you opening your mouth. Question number 4 on the screen. You need to make the court or the officials or the police officers involved in this matter know that the other party is falsifying various information. It's lies. And continue with that. So, for example, if you approach the court, if the other party laid a false complaint and the matter gets heard and it gets kicked out because it was false, what do? You don't leave it there. You go further. You lay a complaint somewhere. If you were arrested on false information, you go to your attorney and tell your attorney to sue this person for a lot of money for laying false charges against you. Do not leave it where it is. And that is how these things work. And many clients come to my office and they get frustrated with my advice to them. They tell me, I'm tired now. It's been 10 years I've been giving into this lady. And I tell the client, it's 10 years. It could have been one day. Because the first time the party done something so silly or making your life hard is the day where you should have stopped it immediately. But you did not do that. You continue for 10 years. And people are interesting. They learn a lot. They learn their behavior and the patterns. So they know, I want to make your life miserable, my ex-partner, my ex-spouse. What works? This works. But if I do that, I know it's illegal, it's improper, but you do nothing about it. So I hope that answers question number 4's question. Let's deal with question number 5. We're now officially 40 minutes into the Zoom webinar, and I'm planning on another maximum 50 more minutes. I'm looking quickly on the, I see 2 hands. Okay, I see the lady that spoke last. I will hold you for 1 second. The next person, I'm going to give that person a chance, and then I will deal with the lady that spoke last, because I see they both their hands up. And then after that, I will deal with question number 5. Yes, that's it. So I'm asking that specific question to unmute your microphone, and once I see it's unmuted, give me 1 second and please speak.
Hi, Advocate. Assalamu alaikum. Can you hear me?
Walaikum salam. Yes, I can hear you, and clear and well, and please go ahead.
Okay, so my particular case is one that has been going on for like 2 or 3 years now. So basically, in the beginning, my ex-husband obviously wanted a divorce, which we proceeded with, and at that time he was involved with someone else. So he wanted very little contact with the child in question. And we proceeded with the settlement of him having contact from a Friday to a Sunday, which was okay. And then I'm at a point now where the grandfather got involved and he pushed the son for more access to the child. And they sort of put me in a corner in 2019 where they asked, where they basically told me that if I do not grant more access, they're going to take me to high court and they're not going to rest until they get what they want because they have a lot of money. So I'm currently in the battle now. As it stands, we are fighting in high court and we've got a date set down for November. And they've asked for a psychologist to get involved. So in terms of both the families, I've remarried, so has my ex-husband, but I kind of sense that there's a jealousy around my husband now and his family in that they are a lot more involved in my child's life. And because of this, I'm constantly being called to court and I'm constantly being summoned. I had to get an interdict against the grandfather because he used to drink, and then when he used to drink he would phone my son and say nasty things about me. So the interdict got put aside, but he had taken an undertaking where he's not allowed to make contact with me whatsoever. I'm a bit worried in the sense that the psychologist may rule something like joint custody, which I don't want. Reason being is because my ex-husband's home is not a stable environment as compared to mine. And they don't really pay attention to the child's schooling as such, but they do try and buy his time with regards to buying him toys and all of that. So I'm a bit scared that they're trying to like sort of reel him in using those tactics. And I just want to know, in terms of the justice system, where does this leave me? Is there a possibility that we may end up with the joint custody, or will I be able to take back some of his days and revert to the original agreement of Friday to a Sunday?
No, thank you very much for that, and I will deal with it now. I think I'll just deal with the last comment which you have made. If you want to revert to the Friday to a Sunday again, you'll obviously have to make an application to court regarding that. So the court will, that needs to be on the table. But that's a technical thing which your lawyer will obviously know how to deal with. This is my advice to you, and it's very pragmatic and how I will deal with a specific matter. The courts make decisions based upon expert reports, and experts make decisions based upon the data which they receive. I am I get very concerned where people do not own their cases. And this is a specific advice to you and whoever's watching this video. You need to own your case. The matter is in the High Court. There's a case number applicable to it. It's a matter of A versus B, mom and dad. Done. You own the case. It's your showroom. You need to present the court with all relevant information and all arguments that you may have that will support the court's decision in granting you primary care, whatever the case may be, or continue with primary care, or dismissing the other party's application, as the case may be. You have that opportunity to do. So your question to me, I don't know some suck things, as opposed to saying you will be successful and you will not be successful. That is wrong for me to do. It doesn't mean anything. Your guess is as good as mine. If somebody said next to me now, his guess or her guess will be as good as my guess. I do not want to guess. I need to give you advice. How to win your case. That's the topic of this webinar. Start with pen and paper. Unpack certain things. Explain to the court or to the psychologist, why do you feel that this new arrangement will not have to work? That's where your application comes to court. Many lawyers, not many lawyers, but some lawyers or some people, when they deal with these type of matters, they say, this is the mom, this is the dad, these are the kids, this is what I want, full stop. That's an affidavit. That's a notice of motion. They file it in the court. Then they leave it to the experts. Now the experts come. The experts meet with the mom. Mom, are you mom? Yes, I'm mom. What do you like to say? Yes, I would like to say that I do not want the other party to have this done. Okay, so it's a very skeleton way of dealing with this matter. Alternatively, let's say you had a legal team who draft this documentation in a very logical fashion, saying we would like to have the following relief. We are opposing joint care because of the following reasons. Historically as well, because in the past this has happened. All the specific information gets recorded and it goes in the judge's brain. And the more you put this information in the court's brain, after the court obviously read it in the affidavit, the court's decision will have to be swayed. And the court will make a decision either in your favor or other party's favor, but the decision will be made based upon the information that was provided to him. And the same with the psychologist. If you want to sway, if you want to have an influence over a psychologist's report, you need some coaching. You need to know, what am I going to present to the psychologist, as opposed to waiting for the psychologist to ask me questions. You have to have a mission. The psychologist is being paid, but I don't know by who, but either by the father or the mother or whoever it is, maybe not charging, I do not know. But if you want that report to be in your favor, you need to make sure that report is in your favor. That's what I'm saying. And how are you to get that report in your favor? By presenting to the psychologist relevant information regarding the child, the other party, the grandparents, whatever the case may be, that could possibly sway the psychologist in deciding in your favor. And if you do not do that, if you take a passive approach in your specific case, the result will also be in the vacuum. In the sense of, if a client comes to me, and obviously we're not successful with all cases, I mean, I will be wrong to say that, but if a client comes to my office and my brief is to be successful in the case. Success has a very relative, subjective meaning to it. But my job is to be successful. I'm not going to be afraid of not presenting information, not arguing matters, challenging the judge and so on, because that is my brief. And if that is my brief and I just stop my client and say, ma'am, please stop. I won't say keep quiet. I say, please stop. Let me finish, because this is very important. It's very important that I bring this point across to you so that I can be successful in your case. I will do that. But my quick answer to you is, to the Pacific commenter, would be, I do not know what the outcome of your case will be, but I can tell you this for sure. It all depends upon what you present to the expert and to the court. And if you do a very good job at that, if you challenge the father's arguments, his paperwork, his comments, his allegations, if the father is saying, no, the grandparents are well involved in the minor children's lives, they help them with school work and so on. Many times the grandparents pay those specific items. He helps him with school work and so on. You say, no, on that specific allegation is not correct. It's a fabrication. He does not help because of the following X, Y, and Z. Then you get a note from the school. The school saying the children are struggling. Whenever they come back from the father's place, they struggle. So they got him 50-50, for example. If 50-50 does get implemented, it would mean specifically that the children will live with the mother for 1 week and the father for the other week. Is the father capable of doing the homework? Has he done it in the past? COVID-19, where the kids are like 1 week with the one parent, 1 week with the other parent. So these are things which we need to present to the other party. You need to use your brain, not your lawyer's brain. The lawyer has his own brain, his own ideas, his own problems in life, whatever the case may be. You need to apply your own mind to a case and find out what is relevant and make sure it gets on the table of the judge or the expert. I hope I assisted you with that, and that goes with the topic, how to win your case, custody or access. Case in the High Court, part 1. If you have any additional questions or comments opposed to that, you are welcome to do so. I'll be happy to answer that. I hope I answered the question. If I haven't, please mention to it. The lady that spoke early on, I will deal with you in 1 second. Let me just deal with question number 5 on the whiteboard. It's a quick question, so I can get the whiteboard also moving down as soon as possible. I see another gentleman also putting his hand up. I will deal with you next after the lady. Question number 5. 2020, I started an application for custody due to alienation. I have a forensic report. She wants another report. Costs are out of control. Can the case be heard without spending more money or years? That is what should happen. A child custody matter should be done expeditiously. 3 months, it should be finalized. The reason why I'm saying so is, if you spend any longer time than that, information gets dwindled, the children's circumstances changes. It's bad. The parents file the application today. Things are relevant. It's fresh data. The father gets 2, 3 weeks or a month to file his specific paperwork. Things are fresh. An expert gets on board. He gets 3 months to finalize his report. We're in court 4 months later. Technically, things are a bit freshy because the reports are fresh. The court can make a decision. Life can go on. If these matters gets postponed for months and years and so on, when the judge reads through this documentation, the kids were 7 years old. When he has to make a decision based upon all this documentation, the kids are 11 years old, 4 years later. How can he make a decision? Must the matter now be postponed another few months for the parties to get another expert to update the report and so on? Therefore, my advice to you is, in some way or another, this matter needs to be finalized sooner or later. It needs to be brought to the court's attention. Alternatively, if you own your case and you make that effort in your case, you need to make sure that those specific forensic reports are available, they are done, they are compiled with, and your lawyer, your advocate, your attorney, or you need to argue this matter needs to be finalized now. Historically, the facts have changed. Either the court's job to be used as a tool to aid in parental alienation. No, the core job is to avoid parental alienation from happening in the first place. Therefore, what sometimes happens is, there's parental issues. The child generally lives with a dad, right? I'm using that example today. So dad is usually the primary caregiver. He looks after the child. Some argument happens between the ex-spouses. The child lives with a mom now. The mother now refuses the dad's contact, whatever the case may be. The mother goes to the High Court, whatever court. She says, court, please, let the minor child so long remain in my care, pending the outcome of the family advocacy investigation or the court process. Now the game gets played. Those specific matters gets postponed and gets postponed for months and months, for this report, for that report, counter reports, supplementary reports, because the last time the matter was heard was 2 years ago when the last report was provided. Parental alienation, people playing the system. Or, for example, I'm not a primary caregiver. I'm the father, the mother is a primary caregiver. I take the kids away from the mother. Make funny allegations in my paperwork saying the mother cannot care for the children, whatsoever the case may be. Kids are with me. The court says, oh, you know what, ma'am, I'm postponing this matter for 3-4 weeks for us to get an expert on board, but in the interim, the kids stay with the dad. Although you are saying the father never looked after the children before, he cannot look after the kids, I'm just making it interim order. 3-4 weeks down the line, we're back in court. It's a different judge. He has a different opinion. He said, no, we're postponing for the Office of the Family Advocate to get on board. Matter gets postponed. Who benefits? The lawyers benefits. No one else benefits. I hope that answered that specific question. And I'll deal with the live commenter. The ladies whose hand was up early on, I will deal with you, then the gentleman afterwards. You're welcome to, I'll ask you to unmute, and you're welcome to pose your additional question.
Additional to our conversation earlier in your discussion, in this particular case that I explained to you, the kids are 12 and 6 years old. And I'd like to know, my partner contributes 100% towards all the children's needs, from their clothing, groceries, uniform. They go to excellent schools, and he covers every single last expense that you could possibly think of. And the ex-wife is an estate agent, and she claims that she has no income for the last 2 years. However, she has been paying, large sums of phone bills up to 4,000 Rand. However, when she's asked to contribute, for example, towards the children's school fees or uniform, she states that she is financially unable to do so. So their dad is completely capable of looking after them. He's used to taking care of them and making sure they're ready for school, etc. And I would like to know, in the case where I've got this criminal charge, she's being charged for assault, GBH, driving recklessly with a child in the car, with her putting it down on paper to say that she's financially not gaining an income and she's unable to contribute financially to the children. In that, with all those factors considered, what are the chances of my partner winning his case for primary care for his children?
No, thank you for that, and I will answer that question for you. Okay, so we're dealing with a situation here whereby one partner, the father, who's not a primary caregiver, is paying all the minor children's expenditure, school fees, clothing, money towards the mother for accommodation, and so on. I'm just being general here. And we have a situation whereby the mother has a bit of a shady background. She's been charged for assault, and whenever she drives with the kids, she drives really wild, and so on. So, can that information be used, the unemployment part, number one, or the mother's personality or being charged for assault, be used in favor of the father in the child custody battle to get primary care? Now, regarding child maintenance, paying child maintenance or not paying child maintenance is not necessarily a factor in determining whether or not the child should live with you. Because you can have a situation where a father pays all the child maintenance, but he has no clue on how to look after a child. Alternatively, you can have a situation where a father cannot care for a child. He's a bad person in the sense of he's very negligent and reckless and so on. But he's paying most probably half the children's expenditure, and he has contact every week for a few hours. Doesn't mean if he doubles his contribution, he now pays for all the minor children's expenditure. Does it mean he can now have more contact? Can you double the contact? So child maintenance contributions and your right to contact doesn't really play a role. And also at the same time, the flip side, if you cannot afford to pay child maintenance, truly cannot afford, I'm not referring to this example, but if you truly cannot afford to contribute towards a minor child's expenditure, but you're the primary caregiver because it's better for you to be the primary caregiver and to care for the child as opposed to the other parent, then the other parent has to come in and contribute towards the expenditure of the child and pay for everything. He or she does not have to contribute to your personal expenditure, the primary caregiver, but he will have an obligation to maintain the minor child. So that is fine. So child maintenance and affordability and wealth does not factor in the sense of saying, okay, you're applying for child custody, let's look at your bank account. You have no money, you can't get primary care. Oh, you do have money, okay, you can have primary care. So it doesn't deal with that. I'm just being simple in simple terms because many people ask me that question. Regarding the mother's shady past, the question I will have to pose is, and this is a fundamental question, can the father care for the minor children just as well as the mother can care for the minor children? Because if not, if he cannot, then obviously the kid should stay with the mother despite the fact that she has a charge against her for assault or she drives recklessly and so on. Obviously, with a child being in the mother's car is very dangerous if she does drive reckless, and hopefully she will stop. But it will be silly and it will be improper if the mother can care for the kids very well. She attends to their homework, their schoolwork, and so on. She alienates the father. That's obviously can't be allowed. But the father himself is incapable of caring for these kids. Maybe at the time because he's self-employed and he can be at home. He can employ domestic workers, nannies, and so on, au pairs. But is it in a minor children's best interest? So my quick answer to you is, if you want to be successful in your specific case, for your partner's case, if he wants to be successful, he needs to demonstrate to the court, based upon, besides all this fluff, besides the fact that he's contributing, which is an important aspect, it shows he's involved in the child's life, but the criminal charge and so on, he is a better primary caregiver for the minor children. If he can show that, then the court can work out the other nuts and bolts. Okay, under those circumstances, the maintenance order must be set aside. The mother's contact will have to be every second weekend, and so on. But he needs to demonstrate that. So you can mention it in the court documentation that the mother has this criminal charge against her, which hasn't been finalized yet. She has not been found guilty yet. But even if she has been found guilty for that, does it make the father a better primary caregiver? If it does, wonderful. If it doesn't, we need to look at other arguments. But still, I would mention it. I think it is relevant to show that the mother has a certain type of a personality, but does it change the facts of the matter? Does it give the father one extra day or one less day? So I hope I answered that specific question, and if you have any additional comments, you're welcome to pose it. I'm just trying to get back onto the Zoom screen. I am there. I see 2 hands up. The gentleman with the... I'll unmute you quickly, and I see there's another person who also put up their hands, and I'll deal with them after. But after I dealt with this specific question now, I will, sorry about that, I will deal with one of the questions that has been posed on the whiteboard. Please go ahead, and you're welcome to speak. Thank you very much.
Afternoon. I trust you can hear me. Afternoon, advocate and all the listeners. It's so difficult to pose a question without having to create a scenario. So let me just do that in the quickest possible time. I got a divorce order many years ago, but it was extremely vague. In that, if I want access to my daughter, I had to get my ex's permission. Anyway, that was all done and dusted. About 2 years back, issues arose in my ex's current relationship: alcohol abuse, suicide of a partner, infidelity, all those type of things. Created an unsettling environment for my daughter that while she was on vacation with me, she didn't want to go back home. And I then requested a meeting with my ex to say, can we sort that and iron out what is going on here now so that we can create the best environment for our kid? Her response to that was, I'm in violation of my court order, and I got lawyers' letters sent to me to say that if I don't fly the kid back immediately, I'll be in violation. So I got legal advice from my lawyer at the time to say that everything that is happening and why my daughter's not wanting to go back, I should have brought to the court's attention when it happened, which was in the period of about 6 months before that. And he said, look, just take the kid back and see if we can't sort this thing out of court. And I was like, all for that, but I beat the door with the ex right now. In other words, because of the divorce order where I needed her permission for everything, everything just came to a dead end over there. So I'm at a place now where my kid goes for counseling, and if ever I need anything formally to be arranged, I have to work through the child and not through the mother. In fact, her lawyers at the time don't respond to me at all either. So I'm wanting to figure out now, if I was to pursue some form of joint custody, I don't really want to separate her from a mom, and I think all this fighting causes instability in the kids more than anything else. But I want something formal where I want them to understand and recognize that whatever environment where she's in currently is not conducive for her, and can we look at something better? But like I said, my counsel previously told me that everything that happened previously, I should have brought to the court's attention at the time, because right now they're going to ask, what is my motives and intentions now? So I think, in a bit of a nutshell, I just want to know, what type of recourse do I have? Should I approach them again? My daughter's at 14 now, at which age can she begin to make decisions for herself? Because there's also a coercion in terms of, it's COVID, you can't fly up and down now, this and that. And so I have to make an effort to fly down, where I'd like her to, be more flexible and fly up and down with me. So that in a nutshell is kind of, maybe if you can advise me, should I pursue it? And I think this is not should I, it's my decision to do it. But I'm trying to do it in a way that has the least amount of ramifications for the child at the end of the day. So if there's comments that you can deliver on that, I'd greatly appreciate it.
No, thank you very much for that specific comment, and I'll be happy to give my view on it. The child is quite old in the sense of 14 years old as opposed to being little, and the voice of the child must be heard. So if the child wants some type of a shared contact arrangement to be in place, or a different contact arrangement to be in place, the child's view thereon must be obviously be applied. Your counsel mentioned about stuff in the past. You should have brought it up then. I'm not much about the past so much. I mean, unless it's something relevant that happened a few weeks ago. But the question is going forward and what is in the mind of child's best interest. So if you believe it is in the child's best interest for you to relook the specific care and contact arrangement, and you have in your mind and you have sat down on a piece of paper and you worked out that this will be a workable situation, a workable scenario. I will not engage with you regarding your specific facts because you will know better than me, but you need to work out, okay, the current situation is that I need to ask a mother permission all the time. That is problematic, and it can cause many problems in the future, and it's not in the child's best interest. That is fine. So you work that out. We need to change it. What is your alternative? It seems to me, as you mentioned now, that I'm presuming that the parties are living in different areas because of COVID-19. You mentioned earlier on that the mother is using that for the traveling aspects, and you have to travel to the child. So you need to figure out what is a workable situation. Obviously, we do not want type of chaos where the mother cannot plan the child's day-to-day activities going forward every Pacific, because you might come out of nowhere on a specific date and say, I want to see the child, etc., or child have contact with me. There needs to be some type of a structure, but work on that. And if you believe, and I honestly believe this, I ask my clients, you need to email me after every consultation. I tell the client, think about what I said and give it a few days, a weekend, and you email me what you think is doable and is workable. I do not know. I do not live your life. I do not know your child. I do not know your other spouse. I do not know you specifically. If you can tell me that this will be workable and in the child's best interest, so what I generally tell the people is, they start from the 1st of January. Okay, with COVID-19 now, we have to factor that in as well. But let's start at the 1st of January. It's holiday time. With who is the child? How should contact be arranged? What should happen? And then we work later on. A different scenario will be the 1st of the week. Monday morning, where does the child wake up? Wake up in my house or in your house? So your situation might be different, your scenario might be different, but you need to determine what is best for your child. Not what me as a lawyer tells you. I'm only a lawyer. I got law. I'm legally studied. I'm legally qualified. I'm not you, number one. I'm not the mother of the child. I'm not the child. Thirdly, you know what is best for your child and what is best under the circumstances. You need to plot that out, own your case, unpack it. And then you say, I think this is best for my child, and this is how I want to proceed with it. Yes, and obviously what is best for your child will be based upon various factors. The past as well. Whatever happened in the past, it is relevant, and you can mention it. But the courts will be more willing to deal with going forward, because we want what's best for the child. And if it means changing the current situation, and it's best for the child, let's do so, as opposed to the court denying you changing the current situation, which is not best for the child because there's something better out there for the child. I hope that answers the question, but you're welcome to add additional comment. I'll be happy to entertain you. Let me quickly deal with the comment on my whiteboard, and I'll deal with the next commenter whose hand is up. But let me first deal with a comment on the whiteboard. Okay, question number 5. Sorry, number 6 now. Okay. In terms of access or custody agreements, how can the court assist in regulating children access to media content, example, age-appropriate movies, video games, own device, etc., while at the other parents' house, etc.? That's an extremely difficult question to answer, because does the courts get involved in stuff like that? Because this is clearly a parenting issue. One parent might think it's fine for the child to watch Netflix, YouTube, and so on, and it might be fine for thousands of different parents out there, thousands different type of households out there. If the movie says, for argument's sake, from 13 years old onwards, but it's a cartoon, like a Spider-Man, a Batman, 13 plus. But if a 10-year-old child watch it in one family, no, it's fine. They can watch it because we all watch it, But another parent family might say, no, the age restriction is 13 years old and you cannot watch it. And that is also maybe right or maybe wrong, I do not know, but it is a people got different views on it. So your question to me is, what can you do? It's a parenting issue. Tomorrow you have the same scenario, for example, where the child wants to wear a certain type of dress code, whereby in one family, one situation, it will be fine, and in other parent situation, it will not be fine. If you're going to court, let's say now your question is, and I see the word court, so the question is, goes before a judge, and you litigate before the judge and say, Judge, this specific parent's way of parenting is allowing the child to look at specific content which is not age appropriate, according to me. Um, the judge might say, Sir, you are not allowed to do that, and you should control your child, and reprimand him and possibly make an order, but I doubt the court will even entertain that. My advice to you is, strong advice to you is, have the child taken to a professional, a social worker, a counselor, and speak to the child and ask the child, you explain to the child, this specific content is not age appropriate, you should not watch it, and if your mother allows you or your dad allows you to watch it, please refuse to watch it. That might be the best way to deal with that matter. And also have a specific professional person contact the other parent and engage with him and explain to him, you know what, there's a complaint on the one side of the fence. You guys both own the specific property, the child, but there's a complaint on the one side of the property saying that you are using this property or allowing the child to watch this video. And that's how the parties can try to resolve the specific matter. I hope it assists you, but it's a co-parenting issue. And maybe see a co-parenting counselor. Go for co-parenting coaching. That might be able to assist you further. Okay, we passed now the halfway mark, I presume. We're dealing with question number 7 soon. There are 13 questions. But before I deal with that, I will ask a live commenter to make a comment or to engage with me. I'll ask you to unmute your microphone. Is it unmuted? Yes, it's unmuted. And you're welcome to speak. Thank you very much.
Hi, how are you?
I'm well.
Oh, thank you. Yes, my problem, okay, is this. My son is 2 years old, ne? And then his father applied for full custody. He's married to someone else, and we were never married. Now, what happened is he was harassing me at work, and I ended up applying for a protection order, and I was given an interim protection order against him. And then on the date of the court case regarding protection order, he was busy provoking me in front of the magistrate that was on duty that day. He was busy like provoking me and all that, and I ended up slapping him. It was okay. The emotions got the better of me, and he opened a common assault case against me. Now, okay, the prosecutor in charge, she referred me to NICRO, the social workers, and I'm busy with the program with them. So I wanted to ask if the program is going very well, and she said that if the report is positive and the feedback is positive, then they will erase the case, because I'm working, and I'm taking care of my child, as a single parent and all that, since he's not the father is not contributing or anything like that. So now I wanted to ask if maybe that incident will have an effect on the full custody, and also the social services, they contacted me and they wanted to come by my place to check everything out, if it's child friendly, if my child can stay there. So I was wondering if I can get some tips on what to look out for, because honestly, I wouldn't want to lose my son over that incident. And yeah, so I wanted to ask something like that, can he use that actually to get the full custody, because he wants the full custody with his wife, and I don't understand why, because other than that incident, he don't have anything on me. He just unprovoked, he went for full custody. It's not like there's any incident in particular that happened, or maybe something that shows that I'm unfit, because I'm working, I'm taking care of my baby and all that. There's nothing actually. Okay, I wouldn't think there's anything wrong with myself. I feel like I'm a civil citizen, and I do have a right to raise my child. But I think for some reasons in his head, he went for full custody application. So I was wondering if that incident in during the magistrate court, will it have any impact on my thingy, on that custody thingy? Will they be really take my baby away from me, or maybe it's something that can be worked with? Thank you.
So you're welcome. And thank you for the question. It's always appreciated. I get such type of intricate questions that applies to real life examples as opposed to me always just answering the general generic questions. So my quick answer to that should be no. It shouldn't affect your case. That is what happened between you and the father. But what you need to do is you need to make sure that the person who's making the assessment, the social worker, understands and sees your reason why you done what you have done. It needs to be recorded, and you do not just presume that the social worker or this person coming to your place knows the facts of the matter. He or she might not know it at all. You need to ensure that he or she knows about it, and you need to come across reasonably. I'll deal with the scenario as shortly. Let's say you are unreasonable, then what could possibly happen? But you need to make sure that the specific person understands what your reasons were there for. And the same with the children's court. You need to ensure that they also understand. They understand what the situation was and the situation and the facts behind it and why you acted the way you have. This is my advice to you holistically. That might be a small dot, and a dot on a big piece of paper doesn't really affect the paper much. A paper is still a white piece of paper. But the question is, and that the court will have to decide upon, and you need to make sure the court understands it, and you push this idea to the courts in order for you to take away all the focus on the alleged assault incident, is that you can truly care better for this minor child than the other parent. You need to make sure of that. And you're working and you have a place for the minor child to stay and you're attending to schools and so on. And the court needs to see that the other party's reason for doing so is this because he wants to have power, maybe, I do not know. What he will do his thing. He will argue his case. And I'm here to assist you in arguing your case. And if the court, you need to convince the court what the consequence will be if you are not the primary caregiver of the minor child. Then the minor child will not be looked after where he has been looked after, or she has been looked after, etc. And that you have the capabilities and the skills. You attend to all his inoculations, his vaccinations. You were there for the first time he walked, etc. So you are his mom and dad, because the dad obviously is not always in the picture. So the court needs to be convinced that you have the capabilities, and that compare that to the other party who only wants to have the child but doesn't have the skills or the capabilities to deal with a specific child. He or she might deal well with their current kids, but not specifically with regard to your specific child. So my quick answer and my quick tips will be to all the viewers and all the listeners, and to yourself as well for the commenter, is push your case forward. And I like saying this: own your case. Push your case forward and let the court know, and the magistrate or the social worker know, that at the end of the day, you can care for the child better than anyone else in this world, even the biological father. And these are the reasons and the facts behind that. I hope that answered that specific question. If I did not deal with it well enough, you're welcome to come back online. I see no other hands, so until I see some hands, people want to partake in this, I'll be happy to let you in. We've got about 10-15 minutes left on this webinar, and we've passed an hour and 18 minutes, so that's quite some time. And let me deal with this quickly. Okay, question number 7. If the other party, being the dad, has money and keeps approaching the High Court to launch applications against you if you don't give in to their demands, how do you put a stop to that? Obviously, you want the court to know that this party is specifically doing that. But I would strongly advise you, you can't necessarily stop someone from going to court, because I don't know the reasons for that, and maybe things are wrong on the one party side. I'm not saying you, and he has a justifiable reason to go to the court. So I can't say that. But I would strongly advise, as I mentioned earlier, own your case. Make sure that the court and officials involved see and understand that this person has a vendetta against you, and this person is using the legal system to make your life miserable, and based upon the fact that he or she has a lot of money as well. So that needs to be brought to the court's attention. And hopefully the people that decides on these type of matters will see that, they'll put it in the judgment, and hopefully it will be recorded somewhere or the other. So I hope that answers your specific question. And I'll deal with question number 8. Safe home for kids 11 and 14. Yes, kids are not safe anywhere, but leaving your kids even for a day at a known drug dealer's house. What? We need urgent help. I would say immediately go to the children's court, get a social worker on board, and let them investigate this matter. Children's court, they know exactly what to do. They will get somebody to investigate this matter and make a decision on that specific issue, and ultimately the matter will go before the magistrate. So I hope I answered that specific question for you. Those who are on the webinar, thank you for staying up so long. I'm seeing the same faces, and thank you for joining and staying with us. Question number 9, and it's 13, and I hope to see a hand up soon if you want to partake with me further. And there are some questions on the Zoom chat as well. Question number 9. How does one mitigate false allegations made? How does one prove parental alienation in order to restore the highest level in contact possible for the parent who has been isolated and alienated? My answer, following from our previous questions, is you need to make sure that your relevant information to show the court that is parental alienation is shown to the court, and at the same time that your child needs you in his or her life. You can provide the child which the mother or the father cannot provide. That's very important. You need to show that to the court. And if you do not do that, obviously the court will just deal with the matter as it is. So number 1 is show the court this parental alienation, show the court the consequences and the consequences of parental alienation, the negative consequences thereof, and at the same time why the child needs you in their life and why parental alienation should not take place. I hope that answers that question. Question number 9. You'll notice that I have capabilities of taking long to answer questions depending upon the time, but I'm rushing it, but I'm still happy. I see one hand coming up. Wonderful. And I will deal with you. Let me deal with all these questions quickly, and then I'll deal with the hand that's up in the next 2-3 minutes time. Question number 10. High Court divorce order in place 2012. Special needs child turning 18. Father stopped maintenance. Circumstances change. Son needs 24/7 care by the mother since 3 years ago. Can't work. How do I proceed? My advice to you is go to the maintenance court as soon as possible and before the child turns 18 years old, because when the child turns 18 years old, he's an adult, and things are a bit more complicated then because you can't claim maintenance on behalf of an adult. So do it as soon as possible. Approach a maintenance court. Quick advice to you, and I'll give quality time to your question. Make sure that you have data and information and documentation, which I'm sure you do have, to show that the child has special needs, that the child requires 24/7 care by the mother, and so on. So there's a historical documentation shown. So when you approach a maintenance court, there isn't much debate regarding the special needs. The only question before the maintenance court would be the fee amount to pay a child maintenance. So we do not know what the father earns, but clearly we can present to the court what your expenditures are for yourself and what the expenditures are for the minor children or minor child in this specific case. That is in your hands. That's where you own the case. So start writing now. Okay, minor child, 17 years old, from Monday to Friday to Sunday, or for the month. These are the following expenditure which the child has. Unpack it, put it down nicely on paper. Explain to the court why the child requires special needs, 24/7 care. If there's documentation available, presented as well. Regarding your expenditure as well, it needs to be presented and so on. So make sure your case is in order and put your best foot forward to be successful in your case. Question number 10. High Court divorce order in place 2012. Sorry, that's question number 10. I dealt with that. Question number 11. How would I refer my case from the regional or district court to the High Court, and what are the pros and cons of doing so? What are the time frames involved? If you started your case in the children's court, it stays there. You need to withdraw the application and proceed in the High Court. It's not, for example, maybe like a divorce matter, which technically can go from one court to another court with the consent of both parties. That I've done in the past. Or maybe a criminal case where it's in the district court and goes to the regional court and so on. Sorry, when it's in the district court, goes to the regional court, and from the regional court to the High Court because of the nature of the matter. But regarding your matter, if it's a children's court matter, you need to withdraw the application and proceed in the High Court. The advantages or disadvantages: High Court, you have a bit more control over your case because the parties have lawyers and the lawyers fight it out, and the and the judge makes a decision. Children's court matters, there you get clerks of the court seems to be a bit more involved in the matter. They seem to postpone matters more, where they keep matters on their files, and so on. So I would say I do not want to discriminate between the two courts. If you can afford legal representation, I would maybe suggest you make use of the High Court. In my view, it's a bit quicker, a bit more better to litigate in. Maybe I'm being biased because I'm an advocate and I specialize more in High Court matters. But if you do not have legal fees, then the Children's Court is there and they seem to assist you. The Magistrates Court seems to be creatures of statutes intended to assist people without legal representation. So that's basically my 2 cents on that specific topic. Thank you for keeping your hand up, sir, and I will deal with you shortly after the next 2 questions. What are my options if we don't have money to fight in the High Court? Remember, legally, you do not have to have a lawyer to represent you in court. You can represent yourself either when you prosecute or when you deal with the matter, when you are applicant or the complainant, or if you're the respondent or defendant. You do not have to have legal representation. You can do it yourself. So your other options obviously would be the Children's Court, because they seem to assist you more, and the magistrate is more like involved in your case. Or you can represent yourself in the High Court. There's legal aid as well. Sometimes they do deal with matters. I do not know how they operate in prosecuting. I do know in a few of my matters where legal aid assisted the other party, where either I was the applicant or and they represented the respondent, or I was on behalf of the respondent and they were for the applicants. And at the same time, there are places like the legal resource centers in your area, or some universities, they have legal aid clinics and so on. So they might be able to assist you. I think it's all based upon your income and whether or not they do that specific type of work. But remember, you do not have to have a lawyer, and there is a Children's Court. And the last question, thank you for keeping your hand up. Is this webinar applicable to custody cases that involve domestic violence against the parent trying to maintain full custody? That was one of the last questions we had when persons that registered. Yes, I'll be happy to attend to that. Unfortunately, we could not engage with you earlier to deal with that and to advise you. We only prepared this whiteboard this morning before this webinar, once we had all the questions and all the registrants. For part 2 of this video, the second part of this webinar, you are welcome to pose a question and I will deal with that. Okay, we have I would say our last live questioner online. Let me deal with that quickly. I'm unmuting your hand and please go ahead.
Thank you again so much, Advocate. Thank you, everybody. And again, great topic. I think one kind of sees a common theme, and that is one of parental alienation. And it's actually quite sad because of the fact that how it actually impacts kids. And how they grow up later on and how they become unbalanced adults because of it. But I guess my question is, you were kind of sort of stating that, if your case is, you need to take, first of all, you need to take ownership of your case. And number 2, you need to push your case forward. Well, I would like to basically ask you, my question would be how is it that I actually push my case forward? Because of the fact that in my situation, I applied immediately once the alienation started. I went to the courts. The matter is now sitting with the social worker, where they have to do draft reports and all of those type of things. And that was last year, May. Okay, I've now not seen my kids now for almost a year. And I've not spoken to them for literally, I think it's now almost 6 months that I've not been able to speak to them, call them, any type of messages. And it doesn't matter whether I follow up with the regional court or whether I follow up with the social worker. All that I'm told is there is a process that needs to be followed. This needs to be done, but nothing is happening. Nobody is calling. Nobody's following up, So my question to you is, how do I push my case forward? How do I actually get it to a point where it now can be heard in front of a magistrate so that this can actually be resolved? So yeah, I guess that'd be it. That'll be, my question is, how do I actually get my case to progress?
Now, thank you very much for your comment, and it's a very valid comment which you are making there. Because all this theory which I'm mentioning over here is that own your case and push your case forward. You know, it means nothing. It could help for some cases, but it's only words, and we need to see results. We need to see action. And if the system itself is failing you, it's like somebody asking your daddy for pocket money, and daddy says no matter how much a child pushes forward, then you hear comments from the father, you know, you're disrespectful, what's your problem, you know, you need a good hiding, whatever the case may be. So I'm with you 100%. Do me a favor, I got ideas. Send me an email later on, right? If you can, whoever else wants to as well, you can do that. Just mention we had this discussion. Send it to info@our-lawyer on the screen, and put your contact details over there. Let me chat to you, because I mean this is something which I want to maybe try to unpack, and maybe we can find some type of a solution to deal with a specific problem, because I'm certain whatever I tell you now will just be theory again, and I'm certain you did try that. And maybe we can dig deeper into that. So pop an email, info@our-lawyer.co.za. I specifically mentioned that we spoke on the webinar. You were the last person to speak, and this is it. And I'll try to deal with that. I hope that helps. And I think we've passed our. I see no further hands. I think we've passed our hour and a half, which was allocated to this. I have some questions that were posed on the chat. Let me just deal with that quickly. I think there's a few comments. Advocate, I would like to ask questions. I dealt with that early on. Good advocate, I would like to pose a question. Dealt with that, sorry. Hi, counsel. I have a matter similar to parental alienation and our attempt to gain full custody from our client, where the mother and the father have been divorced for 7 years. The child is 10 years old. In the child's lifetime, the father has had little to no contact with the child. The child competes internationally, so I'm reading this verbatim, and our child has struggled to obtain his consent to travel, okay, and to renew the child's passport. We previously launched an urgent application to dispense with the father's consent for the child to travel. However, we wish to obtain sole custody for our client, and an application in the High Court at the moment. How can we ensure that the client gets custody? Thank you for that comment. I think at the end of the day is you must just prove to the court that the child's best interest will be adhered to. But I'm trying to read something into this question. Isn't the question guardianship rights? Because when it comes to passport applications and to leave the country, you need to apply for, the guardians have to consent to that. So I think maybe we're referring to guardianship. I think custody, you listen to my previous discussions, and you'll understand that. For a child to apply for a passport, both parents or guardians of the child should consent to it. And if a child wants to leave the country, in terms of the Children's Act, it says, I think section 18, it deals with guardianship rights, and if the child wants to leave the country, leave the republic, it requires both guardians' consent. So my advice to you is, if you're dealing with guardianship over here, apply to the court so that the parent can be the sole guardian of the minor child. Because, and the reason for that is, because whenever it comes to these type of important decisions regarding a passport and getting consent to leave the country, the other party becomes problematic or is not available, whatever the case may be. The High Court might be able to limit what type of guardianship rights you have. So it might say, consent is not required for the minor child to leave the Republic of South Africa and to go overseas to compete and come back again within a month or two's time. If you do stay longer, then obviously the international abduction and the Hague Convention kicks in. So I would advise you to make an application to court for sole guardianship rights for these specific reasons. Other specific items could be, for example, admissions for school, because the school might ask for that type of consent, for medical procedures and so on. Okay, great topic. Thanks for the comment. I have another comment, and I cannot, I think it's regarding the lady, regarding the father pays for everything, and let me deal with that. No, that's not what I'm asking. I'm asking if the mother cannot afford to contribute financially and a criminal charge of assault GBH against her, can those assist her father in gaining custody? I think I dealt with that. No, that specifically will not specifically assist. As I mentioned earlier on, not having money to maintain a child does not give the other party the right to care for the child. The other party has to pay more maintenance for your child. So that is fine. It's two separate issues. And having a charge of assault GPH against you, if you can keep for the child still better than the other parent, those are, it won't necessarily assist the other parent saying, you know, there's a charge of assault GPS against that other parent, based upon that, I think I'm a better caregiver for the child. The question still is, can you care for the child? That needs to be determined. If you can demonstrate to the court that it can care for the child, wonderful. There will be great in your arsenal in the specific matter, whereby you and the mother can care for the children just as well. The advantage you have is that you are financially stable, and that is could possibly assist you here because you guys are on equal footing. At the same time, the mother has a pending criminal matter. So, whose picture has been blurred more, or who has a more of a darker past? Then, under those circumstances, if all else is equal, then it could be the father could be a good candidate to have primary care for the minor child, taking the minor child from the mother's care and placing the child in the father's care, because he can actually care for the child just as well as the mother. Okay, other comment, good question. Thank you so much, advocate, very helpful. Thank you so much. That is the route we are taking. Great. Huge thank you for the webinars and the willingness to share advice. It will have some time to ponder on whether I want to pursue the legal process, only because I consider the possible consequences of the child. Will be in touch in the near future. Wonderful. Thank you very much. And that's it. I think that's a wrap. We have one final comment on the Facebook Live. Let me answer that question quickly. What age can a child also stay with his dad, and what to do when a child wants to live with his dad but the mother doesn't want to? So the age, it depends on the child's maturity. The child does not decide. The child can say what he wants, but the parents decide. Many times children want to stay with one parent as opposed to the other parent because of McDonald's being here or party life being there and life is good here or there. Because at dad's home, they do all the schoolwork, all the homework, but in mom's home, it's a luxury because they're only there on weekends. They go to the pools, they go to the beaches. So we listen to the kids. Why do they want to stay? I want to stay by dad's house because my friends are there and I can do my homework and it's closer to school. Good reason. I want to stay at mom's house because of partying, life is good, all my cousins are there, bad reason. And the court will listen to you and listen to the circumstances. And if one parent does not want to have a change in care and contact arrangements, then obviously what you should do under those circumstances, you need to take the matter to court. Try to agree on a payment plan, but if that cannot happen, it doesn't work, try to mediate. If that doesn't work, you need to go to court. And that's a question on Facebook Live. And I see no further hands going up. Or do I? Or did I miss that? Let me see. No, I think I'm good. Thank you everyone for joining this webinar. I really appreciate it. I will be sending you the link to watch it later on again. Those people who have registered or watch this video late, this webinar is obviously still on Facebook Live, so you can watch it after this video has ended. In 10 minutes time or so, once Facebook processes the video, it should be available again. If you can share this video, it will be greatly appreciated. And thank you again for your time. And I hope to see you at our next webinar. Let me get the topic right. How to win your care, custody, or contact access case in the High Court Part 2, which should be in the next week or two. Thank you very much. Have a lovely day.